without further ado, why don't we hear from the representatives of Halloran and Sage? Are you going to do a duet?
Well, we've not our first rodeo, so to speak, in doing this. We've done this together in different contexts. Rich is going to speak first substantively, but because I was opening my mouth already on the global decision, I'll just introduce myself to folks who I don't know. My name's Ken Slater, and Rich and I tend to do more on the litigation side and the land use side, but a little bit of both. I was very happy with the decision as well. And with that, I'll shut my mouth for a little while and jump in back and forth as we go.
Yeah, we do these more like sports announcers than lecturers. I mean, partly just so you don't get bored. My name is Rich Roberts. As with Ken, I'm a partner at Halloran and Sage. One of the things, I don't do the court work so much. I do more of the, the meetings, the regulations, the review, that kind of stuff. And just by way of background, I sit in your seats twice a month in Weathersfield and have been doing so for quite a while. So, in addition to understanding the law, I also understand the realities of what you guys go through, how you have to interact, how you have to deal with the public, how you have to deal with the applicants and so forth. So, hopefully some of that gets carried through in the sense of, maybe common sense, practical advice for you, since, I generally feel your pain. We weren't really too sure what to cover because some of you are new, most of you are not, but, just kind of some things that I think are worth pointing out. Going over in sort of a general way on procedure rather than the substance of the law. I don't need to give you an explanation of what a planning and zoning commission is, what it does. I mean, basically, you receive applications, you review them in the context of your regulations and the statutes, and you make decisions. Where you generally get into trouble, if you're going to get into trouble, is how you do those tasks. So I think the first thing to keep in mind is that, although it's in a basement in uncomfortable chairs and casual clothes, you are a public agency and you are governed by the laws of the state of Connecticut, the ordinances of Clinton, the charter, and so forth. And in particular, freedom of information with respect to open meetings and proper treatment of public records and public documents. The day-to-day kinds of things, Eric and Julie handle for the most part, as far as, FOI requests and putting documents in the file and responding when people ask for them. I think the things that you need to keep in mind, in the back of your mind particularly, are when groups of people getting together and email chain responses can cross the line to becoming an illegal public meeting. Whenever a quorum of the commission gets together, with certain narrow exceptions, it's considered to be a public meeting if you are doing public business. So if all of you happen to be at the same Christmas party and all you're talking about is how great the cheese is, you don't have to worry, it's not a public meeting. But if you do get together and it's a quorum and you're talking about how crappy the application is, as well as how great the cheese is, you've probably violated the Freedom of Information Act. Similarly, if there's an email string with most or all of you on it talking about things like, who's going to be able to make the meeting on December 7th, we need to make sure we have a quorum. And you respond to that saying, we can or can't attend the meeting. That's not really a substantive discussion of public business, so it probably isn't an illegal or improper public meeting. But if a quorum of you get into an email exchange about the merits of an application or your position on any matter that is either before you or could potentially come before you, that may be seen by freedom of information of being a legal meeting. And generally, the first couple times you do that, they tell you not to do it again, and they make you go train about it. But if it becomes a habit, and particularly if it becomes an egregious habit, there can be fines and other civil penalties for it. I think other than that, the thing to keep in mind from a procedural point of view is that you want to do all of your listening, all of your discussing, all of your kind of back and forth on matters that are before the commission in the meetings and during the public hearings. You don't want to go out into the parking lot and start talking about all the applications. You really don't want to basically take it outside of the confines of the public meeting to do any kinds of deliberations and so forth. Again, I think there's some narrow exceptions, for things like a caucus where it's only members of a political party or something like that, but that, those are generally quite rare. When the public hearing has been opened, you want to make sure that all the information that you have on the application that you may be bringing to the table that you think is important to you and to the commission and to the deliberations gets put into the record at the public hearing so that the applicant, the public, and so forth get a chance to hear what it is that you're using as the basis for your thought process. And also, if there's something erroneous in it, they get a chance to kind of respond to it. It's unfortunate if the public hearing is closed and then you start talking about things that could have been disclosed during the public hearing. I'll let Ken talk more about that, but I think those are the kind of the fundamentals to keep in mind is that when you're talking about factual things that weigh into your decision making, you want to make sure that it's all covered during the public hearing to the greatest extent possible. I think one of the other things that I want to cover briefly, and as with any of these things, if you have questions of us along the way or later on, feel free to ask. During the course of your service on the commission, you may find situations where you have either a real or a perceived conflict of interest. The statutes are pretty narrow in terms of defining what by statute is a conflict of interest. It's generally situations where you have either a financial or a personal interest in the application, or a member of your immediate family does. If you're the applicant, if you're the immediate butter to the applicant, if you're an investor in the entity that's making the application, you may have a financial or a personal interest in the subject matter and should recuse yourself. Where it gets a little dicier is when there's a perception or a potential conflict of interest. It's a quarter mile from your house. It's an organization of which you're a member, but not necessarily, the only member. Then I think you have to kind of weigh in your mind, will I still be able to view this objectively? And I think equally importantly, whether, given all of the facts and circumstances, whether the public would perceive you to have a conflict of interest in that situation or not. Because frankly, the public perception of having a fair process is as important, if not more so, than whether you, in your heart of hearts, believe that you're able to look at it fairly. If people sitting in the audience or the applicant say, well, the fix was in because he's best buddies with so-and-so, then you're kind of undermining the credibility of the process. I don't know. Have some thoughts?
Question on that.
Yeah.
So I agree that somebody should recuse themselves, but they don't have to. Tell me if I'm wrong, they don't have to, there's no legal statute that says they have to, they just put the decision in jeopardy.
Well, I think there are certain things, certain statutes where you do have to recuse yourself, where you have a personal or financial interest in the application before you, where you are the applicant, you are the abutter to the applicant, or something like that. You know, those situations, you do have a statutory conflict of interest and have to recuse yourself. When you get over into the gray areas, you know, then it's kind of up to you to, you know, probably, you know, do the soul searching, as well as, you know, if you think it's going to be an issue, put it on the record saying, you know, I did work for so-and-so, or, you know, this person built my house in 1983, you know, I haven't done any business with him since then, we're not social friends, I think I can, you know, I can deal with this fairly. But there are certain situations where if you do have either a financial or a personal interest, or someone in your immediate family does, then you do have to recuse yourself.
So could the chairman ever, the way it's been in the past is that the chairman has said, I cannot make a person recuse themselves at all.
That's correct, absolutely. And so you say nobody can make me.
So the only recourse would be that it would be good for the chairman to really inform the member of the statutory commitment.
Right, just like the body itself, I mean, you can make a giant mistake as a body and do something that's directly contrary to the general statutes. You did it, and then it's subject to reversal by a court. So, you know, hopefully any member of the commission who understands the responsibility is going to do the right thing, and if they have a conflict, they'll step down. But the board can't vote, you know, and all but you vote that you should step down, and you're required to step down. It's strictly your decision, and then the chips have to fall where they may. But you just have to, you know, you have to use your discretion. I mean, we've got a situation right now. Building on what Rich was talking about, I mean, you are members of the government, and you're judges in some ways, you're a jury in some ways, which I'll tie into in a way. So you have to. It's a small town. I serve on local commissions, and I understand how it is when you're going to be, you're going to the local grocery store, you're at the library or whatever, and you've got a concerned member of the public who wants to get your ear. Try to use your office. You know, I know judges that I really get along with, and I'd be happy to talk baseball with them. But I know better than to try to talk about anything related to any case. And if I tried, I'd be immediately shut down. If you make it a practice of, you know, among your friends, among your family, whatever, that, you know, I can't talk to you about matters involving the planning and zoning. I'm serving in the commission. That's my job. You're welcome to come to a meeting. I've known you since since we're in high school together. So please understand. To the extent that you can do that and set a tone that way, it's less likely you're going to put yourself in a difficult spot where you are overheard at a cocktail party talking about something, and then a commission, somebody tries to take advantage of that and say that you have a bias for or against them. And along that same token, if you think about the body, individually, you're members of the commission, you don't have any powers yourself. You have powers in the course of these meetings when they get convened, of persuading other people at the table of what you should do or what you shouldn't do. And so, to the extent that you want to push an issue, you think the commission ought to go down a particular path, there's a pending application and you need some additional information, or you think the hearing should be open. To the extent you try to do any of that outside of the confines of the public meeting, you run some risks. And that even includes, to the extent an individual may believe really strongly about something, but if they are, there's a sort of a paper trail of advocating something, even with another commissioner, it might not be a meeting, or with staff. you're much better airing that stuff in the open confines of the meeting, because you never know, in the global litigation, for example, if there wasn't any discovery that took place, meaning that there were no depositions of staff or the chairman or members of the commission. But every now and then that happens, that there's some indication that Global believed there was enough on the record to try to persuade the court they were denied due process because some research was done behind, outside of the confines of the meeting. I personally think that doing some legal research and understanding and raising that during the course of the hearing wasn't problematic, but and frankly the court didn't either. But doing independent research, maybe looking at a regulation is one thing, but doing independent research, that you run the risk, especially if the public hearing is closed and all of a sudden you start having discussions and you say, and when I reviewed such and such an article on the designs of septic systems, I've discovered that this plan is problematic, and the applicant has got his hands up like this and say, this was never presented during the hearing, and you've got a real problem. So if you're constantly wearing that hat of how would it look if the discovery was had and all the emails were put on the table, if staff was put under oath and had to answer questions about, isn't it true that Mr. Kravitz told you over and over again that he didn't trust this applicant, that this applicant should, submit an application and we should deny every application. I mean, that kind of, not even a paper trail, those kinds of discussions, can come back to haunt. So if you use your discretion like you're a judge and keep your cards close to the vest when you're out socially, even among yourselves, and raise the points that you want to raise in the context of an open meeting, it makes it so much easier for us to defend it if we need to, and greatly reduce the likelihood there's even going to be an appeal issue in the first place. Now, in terms of that research that I mentioned, the same thing is if you get information, it's called ex parte, outside of the confines of this meeting, somebody leaves in your mailbox, a photograph of the applicant, handing a $20 bill to a member of public, right? And there it is in your mailbox. You can't unsee it. So when something like that happens, I mean, first of all, as I said a minute ago, do everything you can to avoid putting yourself in a situation. But if it lands in your lap, and then that's something that you might have to, you should disclose during the course of the meeting. It's like, right, somebody left this in my mailbox. I opened it up, and here it is. And that's kind of an absurd example, but that kind of thing. Somebody might send you a drainage report that's related to this. If you see it's on letterhead that it's going to be business that you shouldn't be looking at, and you don't look at it, that's another story. You don't open up the envelope, you didn't see it, you don't have to say it's been received. But if somehow somebody whispers in your ear and tells you something, the classic case that gets cited all the time, in fact it was even cited in the global decision, involved a dispute, and there was a location of a well, and a commissioner walked down the property and did a drawing identifying the location of a well, and this commission reviewed it and decided the application in part based on that information that was received after the close of the public hearing. So the applicant was never afforded an opportunity to comment on that. So that's why, even in terms of the conflict situation, if you really think that you don't have to disclose situations on the record, but you can even put a member, go back to the analogy of a judge. That judges say to somebody, I've known Ken since he was in law school, and he was involved in some early case I was with. I don't have, it's been a long, long time, I don't have any qualms about hearing a case before him, and I'll be fair and impartial. But if you have any concern with that, fellow members of my opposing counsel, let me know, and I can recuse myself. If it's a real close call and people know it's a close call, sometimes you might want to say on the record, I was this guy's, realtor for a bunch of years. I know him, but I do work for a lot of other people. I don't have any bias towards or against them. I feel qualified to vote. But, do you have any concerns? The applicant doesn't say, I think you shouldn't sit. then he will have waived his opportunity to do that. So sometimes, I'm not saying you should do that every time, because then you don't want to necessarily invite people, when you really believe you're qualified to vote, you don't necessarily want to invite somebody to say no. But if the situation is right, just put some things on the table like that. If you've reviewed things, if you have special knowledge, there's cases that say that if you have special, you're an engineer on, I mentioned the septic system, you're an engineer and you've designed them, and you have intimate knowledge with the drainage manual or the public health code or what have you, and there's a dispute between a couple of experts on how that code should be applied to the application, and it turns out you have personal knowledge. Don't wait until the close of the public hearing and then drop it in the record that I've been, an engineer that designed these systems for the last 30 years, and what I think is they've made a mistake on the way they've applied, X law, and this is what the answer should be. That's a problem. But if you say during the course of the hearing, you should know I'm an engineer, and you should know this is my training, and you should comment on about the evidence, so you've given an opportunity for the applicant or members of the public to understand what you're considering, so that they have an opportunity to say, again, I'll use Mr. Kravitz as chair of the meeting. Mr. Kravitz stated that based on his experience, this system would be the proper one here. I'd like to add, I think he may be overlooking that this other system has just been adopted by the Department of Public Health as being the preferred system, so they have an opportunity to comment. The commission might ultimately agree with your analysis, but at least the applicants had an opportunity to comment and has been given a fair hearing. And that, the Global case is an excellent case on a couple of those points, because the court ultimately ruled that Global had a fair hearing, that with respect to the research that one of the commissioners did, that it was disclosed, it was legal research, it was disclosed, but Global had an opportunity to comment on it. That, the fact that there was a site visit, members are permitted to rely on some of their personal knowledge. If it's expert information, that has to be disclosed. If it's general familiarity with the property, if there's something unique, if you're not relying on something unique, like the well example that I gave you before, but you simply took a look at the property to understand it better, that's not likely to be a situation in which the commission is going to overrule you. That said, back to what I was saying earlier, to the extent you can follow the ordinary process, if the commission has a site visit, do that. If you think a site visit should be had, rather than just go out yourself and do one, raise it during the course of a meeting and advocate that to the body. And the body can decide to do that, because it's only any decision that's made here, with the exception of setting agendas and doing some of the procedural stuff that a chairman would do. Most everything, or everything, is done by the collective of the group and not by any authority that any one of you individuals have. One last thing on that is, we talked about judge and jury. We've had some questions about what alternates should do, and you have them seated at the table, which we recommend that you do. And they've recently heard some that are suggesting that once the meeting is set and someone is an alternate, that they shouldn't be sitting at the table. You don't know till the moment the vote is had who's going to be seated. I mean, someone who might be the seated member might get a phone call that their wife's batteries, died out at the Walmart parking lot and have to run out of the meeting, and that somebody else has to be seated for that person. The alternate who's been sitting all along, listening to the hearing, assuming that they've gotten themselves familiar and sat through it, could be seated. So up until that point in time, you don't know. Once a matter is going to be deliberated on, though, and once sort of the jury panel has been set, if you were a jury, the jury would be excused at the moment the question is put to the jury and the jury goes off in the jury room. The same thing is true when you are going to deliberate. Once that point in time happens, if you're an alternate, you shouldn't participate in the deliberations and offer your opinion. Only the people who are seated and who are actually going to vote should be the ones to deliberate the matter. Earlier in the process, when you don't know whether or not you're ultimately going to vote, you can make comments, you can ask questions the same way a full member has during the course of the public hearing, because you don't know whether you're going to be the man or woman who's actually going to be casting a vote.
Any questions thus far?
Yeah, I have a question about the notion of, you said something that comes before, something before the commission, or something that is likely to come before the commission. None of us knows the future. Exactly how specific specific are we with regard to something that might come before the commission? I mean, suppose that I were talking back and forth with somebody about the merits and disadvantages of floating zones. Is that something that is, that I shouldn't be talking about with somebody else? Should I be reading professional papers on it? Should I be looking at zoning regulations of other cities and towns to see how they handle them? Because, I don't know whether that's going to come before us or not.
I guess my thought on that is that, if it's something that is of sort of general interest, kind of planning topics that come up, the idea of floating zones, the idea of mixed uses, that kind of thing, I think it's perfectly fine to, educate yourself and even discuss, during the other business portion of the meeting, kind of general, hypothetical, academic concepts. Once you get it to the point where you can land it on the earth, say, wouldn't it be great to have a mixed-use floating zone for the X property? Then I think, you probably need to be a little more careful, because at that point you're making a specific kind of analysis and determination of something that is within your purview, whether or not it's a live application.
What if it's recommended in the town plan?
Well, I think that was the next thing I was going to say, is that, that's the kind of conversation you want to have when you are discussing the plan of conservation and development is, what direction would we like to take this part of town, in terms of, what kinds of land uses and densities and so forth are going to be there, what would we prefer to keep out? I mean, those are kind of general policy decisions that are within the scope of your powers and your jurisdiction when you're doing that. I guess if there was a piece of property that's been problematic, and someone heard a rumbling that, X company is going to come in with an application for, a fish refinery or something like that, to kind of have a long and belabored discussion about that prior to, an application being filed may be problematic. If the application is filed, and you're unanimously on record as opposing it regardless of what, that application constitutes. But I think, kind of 10,000-foot policy analysis of, planning your community, even when it does come down to, particular parcels, should this stay in the X zone or should we move it to the Y zone? Those are things that are within your jurisdiction, but they should be done in the context of a discussion about that so that the public can be aware that that's what the discussion is going to be about.
Well, that gets back to the matter of, the legality of, subcommittees or ad hoc committees being appointed to do some of these things. We've just adopted the new PSCD. Our question going forward is, now we must implement it, which means drafting regulations. I can't see 12 of us sitting here going through and drafting regulations or even doing the commentary upon them. I think that that's the kind of thing that would be, you want to first pass over. I mean, a professional probably would be the person who would draft it, but then I think you'd want to first pass by people who have, a particular interest in drafting regulations and in the planning process, and that might be a group of 4 people. And obviously, nothing is voted upon or implemented by those 4 people, but they might be sitting there saying, gee, I don't know about the drainage, I don't know about the sight lines, what about the this, that, the other, the traffic. How do we handle something like that?
I don't know if you've talked about it specifically. We have this issue right now that was just briefed, where an applicant was suggesting that you would deny fair process because subcommittee of the commission had worked on evaluation of certain aspects of the application and made a recommendation to the
Well,
body.
I'm not even
as a
talking
whole.
about an application being in place. I mean, I'm talking about, suppose we wanted to draft regulations for some kind of floating zone.
Well, I guess I would say, set up a formal committee to do it and keep minutes, and then, you know, it's a public agency, and you're making it a public record, and if you're having a meeting, do it in public, and, you know, you shouldn't have anything to worry about. I mean, I guess where I would be more concerned is that if you had, you know, the secret POCD implementation committee that met in the bunker and then, you know, showed up at the meeting, you know, here's what we're gonna do. You know, I would say just have a meeting, post the agenda, use fewer tables, and, you know, and just do the business in public.
And clearly, if it's policy making, I don't think there's any issue with it. And to tell you the truth, I think this particular matter, where they did it on an application, is going to be upheld. Because there were some complex issues, and they wanted to get this application reviewed very carefully by folks who had some time and make some presentations on some detailed aspects. And then ultimately, all of it was aired in the context of the full board. So we'll see what the Superior Court has to say about it. But I didn't see any issue, and I think it was very defensible in you know, on a case by case basis. But I was going to add what Rich said, which is follow the FOI and treat the subcommittee as if it's an agency to the extent that it.
Related question, very close to it, pre-applications. I know we're going to be getting some pre-apps, and how far can you go in terms of commenting, judgment about elements of a pre-application?
Common sense test is the most important one, which is, you know, when they get to go, they say, I'll never consider an application like that, no matter what you present. Bad idea. But when there's no reason why you don't provide some guidance to the applicant of some things that you think need to be included, some things that you're concerned about, do it in a way that suggests that you haven't made up your mind. But that's the purpose of the pre-app, is to just get some feedback. The applicant may see that you really have a concern in a particular area or not. But just be careful that the things that you say don't suggest that you've closed your mind up. But they can be evaluated. There's some commissions who think just don't do them. And just, you know, pin the tail on the donkey, apply the application, and we'll apply the regulations to it. But if you do it as an exercise to direct people in a way that you want to, and provide, you know, information to them, just do it with that mindset that everything you say could get plunked down later, that somebody's going to say you prejudge the decision both for and against. So I think you can very easily be careful in your words and not run much risk for that.
Yeah, I mean, in our commission, we generally only see them for things that are either likely to be big or controversial. You know, before somebody spends $100,000 on the engineering, they want to find out whether it's going to fly. And, you know, at the beginning of it, you know, the planner says, you know, bear in mind, this is, you know, under this statute, it's informal, it's not binding. And by and large, we try to stick to such things as, you know, it's kind of concerning that you have that density of development with only one way in and one way out. We think it might be better if these driveways lined up and were signalized rather than, you know, offset. I think one of the most recent ones, we said you might want to look at the last 3 applications that are alarmingly similar to this one that, you know, failed to be approved because of certain reasons. You know, there was one that actually we have the public hearing open now, but at the pre-application, you know, we telegraphed some concerns about their interpretation of the zoning regulations. You know, things like minimum lot size and how you measure the setbacks and what compatibility with the neighborhood meant to various people on the commission as sort of a, you know, kind of a generic concept, you know, not particularly tied to that project. And we drew examples from other places in town. And at the end, again, it was, keep in mind, it's your nickel, you can come in with whatever application you want. But, here are some initial thoughts based on what we're looking at. So I think, as long as you sandwich your analysis with the disclaimers and as Ken said, don't either have everyone, say, oh my God, please don't waste your time and money coming in with this crap. Or, this is the best thing I've ever seen, I don't care what anyone in the public says about it, we're going to approve it. So, just keep your cards close to your vest on that one.
I have a question. So somebody comes before us and they bring an expert. They do, the expert technically is given testimony, right? And somebody on the commission says, well, I disagree with you. Aren't we obliged to give him the presumption of truth? Not if.
Depends. How's that for a great lawyer answer?
Yeah, really. What's that, the Unistar case? Are we ever going to get paid for that?
If it's a matter of technical expertise that's beyond your authority to decide, and one classic one is not in this commission, but a wetlands agency, there's case law that says whether something is adversely impacting a wetland is a matter of technical sophistication beyond the ordinary knowledge of lay people. So in that case, if there's no experts, the poor lay people have to figure out if there's going to be impacts without any experts. But if an expert comes in and testifies on an issue regarding wetland impact, the commission can't disregard that expert opinion. All right? Now, there are other kinds of information. Traffic is one of the classic ones, where there's a lot of case law that says that you are the members of the community that understand traffic and have knowledge about traffic. And there's some good law that you have the ability to rely on your own knowledge of the traffic. So a traffic expert comes in and says, this is going to be fabulous, and this is why. There is some law that would say you don't have to adhere to what the expert says. Now, I'll draw an even finer point on now, though, is if the expert comes in and says, well, there's a specific standard on sight lines, and I've done the math, and here, and gives you a diagram and shows everything to the nth, and that's submitted in the record, and you just cross your arms and say, I don't believe you. You're probably going to have a problem defending that on appeal. So there's still some instances where an expert, if it's unrebutted expert testimony, you might have to rely on it. But traffic, property values, there's certain things in which you are assumed to have special knowledge of the community that you do not have to rely on everything that expert says. And if it's a close call, that's one where you might suggest to the chairman and the body, maybe we need some legal advice on that, or staff will say maybe we should get some legal advice on that point and decide if it's a close call. But you've got particularly good guidance, so I think they'll identify any areas where
In technical issues, very often, there are technical standards, and you go to one engineer, you go to another. The problem is not there. The problem is the assumptions of comparability, that this project is comparable to Project A. How does one go about challenging that?
I think you asked the question.
We find, my experience with peer reviews is they often don't want to challenge some of those assumptions, but that they focus on the methodology, the technical methodology, the standards, if you will. But those standards are not written in stone.
You tease them out, and as Rich said, you ask the questions, ask the hard questions, and if it doesn't look, if it looks like there's an assumption that even your peer review experts looked at that you think they might have missed something, I mean, that's something that you could, again, as a body, could say, I think we should ask our consultant to explain to us what she meant when she said this is a reasonable assumption, and ask the question of them. But it's got to get out there.
If we're going to ask for a legal opinion or an opinion from our planning consultant, should we not close the public hearing? Because we're asking for some additional information that the applicant will not be able to,
Well, you use your judgment. You're entitled to receive legal opinions and opinions from your consultants after the close of the public hearing, provided no new information is provided. Now, the risk you have with new information is with your expert more than with the legal advice, because we're not, the facts are the facts. We're just going to tell you what we think the law is. But if there's an open factual issue that legal advice might change the way you look at it, then keep the hearing open, give the legal advice, and then both sides can react. So there's no absolute answer on that. You can definitely receive commentary though after the closing of the public hearing.
That's legal opinion. What about planning?
Planning can look at anything that's submitted in the record. Planning can look at anything and then give you their perspective and advice. Now, if planning comes in and says, but you hadn't seen the report that the EPA prepared a month ago and submits that as an attachment to the report, then that's a problem.
So the review should take place early in the process so that that doesn't happen.
Yeah, I mean, and I think as with everything, you want the substantive discussions where the applicant might want to rebut it to happen while the hearing is still open. Give the drainage report to the engineer and he looks at it and says, yeah, that looks right. Where you get into a gray area is after you've closed the hearing and the engineer is going back and forth with the applicant's engineer and they're redesigning things to make sure that it satisfies the requirements for the 25-year storm or something like that. There actually was a case, Superior Court case relatively recently on a subdivision where after the hearing was closed, the town planner submitted a memo to the commission lambasting the applicant's choice of open space dedication, and advising the denial of the application because the open space was, I forget whether it was inadequate or, just not suitable for anything or didn't comply with the regulations. And the applicant said, wait a minute, this is new information, we have a different opinion on that, and it was all presented, to the commission after the hearing had closed. We didn't get a fair shot, and the court said, yeah, you're right, do-over. At the end of the day, that's the last thing you want to do is, if you've agonized through a hearing, is to have to agonize through it again. And I think at the beginning of what I was saying, it's like, you guys are probably generally going to be okay on your kind of gut reaction of how the regulations apply to, an application and, what in your heart of hearts you think should be the development patterns in the town of Clinton. Where you're going to get hammered is on the little picayune stuff of, not giving adequate notice of the hearing, somebody voting who shouldn't have voted, an alternate participating in deliberations, staff giving you a memorandum, with prejudicial information after the close of the hearing. And I think probably the unfortunate thing is that, people who want to challenge commission decisions are onto it. And I think I've seen more accusations of conflict of interest and bias being raised in the last 3 years, just because that's kind of the flavor of the month as far as, well, we're not going to get them on abusing privilege or, abusing their discretion. We're not going to be able to get them on the substance of it. Let's just kind of pound away at the process. So don't take it personally, because that's what everybody's kind of lashing out at, is trying to find something they can hang their hat on as a basis for overturning your decision. Is, either the process was wrong, or, somebody had made their mind up, or, one of you people, volunteering your time, said the wrong thing at 1:15 in the morning after the public hearing. So,
Well, what are we really voting? When we vote, are we voting on whether they met all the regulations? Are we voting on whether they met all the regulations but we still don't want it in our town? What is the theory behind what our vote really is saying?
The first one.
Yeah, it's generally, does this application comply with our zoning regulations? And quite often, when you're in the discretionary ones, like special permits, there are some subjective criteria where you have to analyze, is this consistent with the plan of conservation and development? You know, is it in harmony with the neighborhood? You know, does it adversely affect property values? Those kinds of things, you know, are a proper basis for you to make your determination. And, you know, using global as an example, there were specific issues that were raised, you know, like trucks getting into the wrong lane, the road isn't wide enough, this thing's gonna blow up. You know, but also, you know, this isn't what should be in this neighborhood, you know, and that sort of thing. So I think as long as you can identify specific criteria in your regulations that support your decision either for or against an application, that's how you should make your motion, that's how you should make your decisions. If the criteria that are specifically in the regulations allow you to talk about things like, you know, the warm and fuzzy of the POCD and harmony with the neighborhood and, you know, public health, safety, and welfare and that kind of thing, you know, all the more power to you. But you need to tie it back down to a specific regulatory provision.
So for a special exception, we need to have something in our regulations that allows us to evaluate whether or not this is consistent with the POCD, or whether or not it depresses property values in the neighborhood. We specifically have to somehow say that in our regs.
Well,
It's in there.
yeah, you have,
already do.
even in the global decision, there's a giant footnote, Judge Berger's decision, that talks about that theoretical special permit review is supposed to be administrative review in the sense that if you meet the regulations, you have to be approved. But then, citing some other law, some other slightly more recent cases, they recognize that special permit criteria are inherently discretionary. So you still have to look at your regs, and you do have a lot of those discretionary regulations, and did a good job in global from both your decision and your deliberations of tying into those regulations, and made our job a lot easier in being able to demonstrate that the court decision should be upheld. So you'll find them there, but either way, if it's not a special permit, you're dealing with purely a site plan,
Yeah, that's
and you don't like it, you wish, you know, you've got enough self-storage places in this area, you don't need another one, but it meets all the regs, you just gotta consider changing the regs, but that application meets it, you grin and bear it. and you
That
gotta-
doesn't happen all the time. I mean, that's, for me, that's one of the biggest issues living in the town for 48 years. A lot of times it is, we don't want another Burger King. I'm just using an example. They met all the regulations, but the body, not this body, but earlier bodies have said no. And that's why I wanted to clarify that if they meet a regulation, it's not a special exception, whether you want it or you don't want it. And sometimes I should also say, conversely, this commission has voted even when they didn't want something. On top of that, the plan of conservation and development, the legality of it, and how it ties into our regulations. It's how many pages? 160 pages.
180.
180 pages. Is that directly tied to?
The last 20 are the
Sounds like Obamacare.
Is it that somebody has to meet all the regulations and the plan of conservation and development? Because we always say that at the end of our, we always use the words and is consistent with the plan of conservation and development. But what does that really mean? Is it discretionary? Because that would really be a problem at 180 pages.
Well, it's not a regulatory document, so usually consistency is when you're dealing with one of these regulations that have a bigger picture issue, like a consideration of a special permit, things like that, where you're evaluating whether something fits into the community. It might be regulation that will refer to that. But if you're dealing, maybe as a matter of practice, it's just in the motion, but if you're dealing with the example of a pure site plan, I mean, that is no discretion whatsoever, meets it all, the plan of conservation really doesn't come into play. So it's all a function of the level of discretion. The more discretion involved under your regulations, the more likely, then that provides a guidance document, but it's not written as a regulatory document like your zoning regulations are, where you can turn to section 2.78 and it says you must have this setback and this height and this coverage. It's a different kind of document.
If I could, a broader discretion, to sort of the opposite end of that spectrum, a broader discretionary question would be the changing of the zone. Whether you're changing a zone from a residential to a commercial or a commercial to a mixed use. That's when the discretion and the content of the plan of conservation and development should theoretically come into play. Because this document, which is still in layout phase, is should provide that guidance and provide that backup, that in this area of town, this is the sort of thing that we want to see. And therefore, this proposed zone change, map change, would be appropriate. And I'll give you an example. Another fairly recent example was when the representative of CVS came in to talk about the corner of 145 and 1, the motel property. They came in on a concept phase and recognized that if a CVS were to get developed there, they would need to change the zone because it's in the village zone right now. And the village zone wouldn't allow something like that. And so the Planning and Zoning Commission had to take a look at the plan of conservation and development that existed at the time and say, would this be appropriate? But then the developers got the idea very quickly that this was not something that Planning and Zoning was keen on at the time. But then, sort of in response to that, the Planning and Zoning Commission made quite clear that in this plan of conservation and development, the rezoning of that corner was not something that they wanted to see. And so there is specific language in this document about that area, sort of not being included in sort of the East End focus area or the development distribution area focus area. And so there is specific language in this document about what they would like to see or conversely not like to see in that area. So, your discretion to change zoning.
I get it, but all I've heard so far is that it's a guide.
Yeah.
And has no real legal.
Oh, it has legal, I mean.
How?
Well,
Give me an example of how somebody could legally say, well, based on the plan of conservation and development, you can't do that.
If for instance, there's a section in here indicating what sorts of uses would be appropriate in the industrial park, the non-road industrial area. If someone proposed high-rise apartments there and moved to change the zoning to allow multifamily in the non-road industrial area, and you looked at the plan of conservation and development and said, well, this pretty clearly says it shouldn't happen there, but we're approving it anyway, you're giving a pretty solid appeal basis for someone to challenge your decision. Because you made a decision that was pretty clearly not in harmony with the plan of conservation and development. And I'll look to Rich and Ken to provide a caveat on that. But
No, actually, that was the example I was going to give, is that it's almost more a legal document in the negative, because, I'm guessing somewhere in the 1,000 pages of your zoning regulations, it says that, these kinds of applications must be consistent with the plan of conservation and development. If you have a section in there that says, we want to provide a diversity of housing styles, but no more blue houses, and somebody comes in with an application for a blue house, and you go, oh, that's nice, an opponent can say, it failed to satisfy the requirements because it's clearly contrary to the plan of conservation and development. I mean, it is a guidance document, but it does have consequences. And I think if you are going to be making decisions that are either directly or potentially inconsistent with what's in the plan of conservation and development, you want to make sure that you are aware of that and discuss it in the course of your deliberations, so that you know, to the extent that you're making decisions as part of your comprehensive plan that are inconsistent with that document, it's on the record.
And those would be, the statutory time where you have to look at it is when you're considering the zone changes, the district changes that John was talking about. And, you know, but it is an advisory document. If you're dealing with a small parcel, you're going to have a spot zone claim, and they're going to point to the plan of conservation and development, it'll be difficult to defend. If 8 years after you looked at a plan of conservation and development, there's a region of town that you've realized circumstances have changed, and you as a body think that the regulations ought to be changed in a way that is thoughtful and, you know, that's something, as Rich just said, you can do it. You're not even bound by doing, by following it in, as long as it's defensible in a big picture sense, and you should discuss it.
And an applicant can, if they wish, petition for a change and amendment to the town plan of conservation and development. If they want to propose a development that's inconsistent, totally inconsistent, they can ask.
And I just thought it was an important question because during a public hearing, we could get people trying to use that document as leverage for or in a negative, and knowing exactly what that document is and can do. I think that's a great example. The biggest one is that it's something can be challenged.
Yeah, I mean, and frankly, in my tenure on our commission, the only time anyone other than the commission ever talks about the plan of conservation and development is when someone opposing something has cherry-picked out of context a page and says, well, you know, you're on page 82, you say, you know, we should have no more commercial development. It's like, well, yeah, that's, you know, here, not there, and, you know, thank you for downloading it, you know.
Somebody did look at it.
Yeah, right.
Any other questions? We seem to be drifting towards John.
Well, I just have a question about the criteria for approving or not approving an application for a special exception. You know, maybe you could hit the top 2 or 3 points that would be reasons for not approving a special exception and the considerations based upon how it should be approved.
Well, there's different, you're going to have different standards. You'll have an overall section, and I'm not sure, I happen to have the Vogel decision, and I'm not sure if the judge cited, though. You have a general set of standards that apply to any special permits, and then you have certain uses that will have particularized ones for that use. So I hate to send you in the wrong direction and pretend that I can rattle off the sections of the regs that have those general considerations, you know, that relate to, you know, the section cites section 9.23. Regulations may approve a special exception if it determines that the proposed building, structures, and/or use will conform to the following general conditions, in addition to any special standards herein specified, which would apply to certain uses, that the streets serving the proposed use are adequate to carry prospective traffic. The provision is made for entering and leaving the property in such a manner that no undue hazard to traffic or other traffic congestion is created, and that adequate off-street parking. There's a set, that's one of the regulations that you keyed on, and...
But you're saying that we already have it.
Yeah,
we already have it in our regs.
I thought that was your question, an
Special
example
exception.
of one. Yes, that's already...
What the criteria.
I mean, in general, it sort of also depends on how dramatically you're opposed to the potential use. Because it's, you know, if it's, you know, the general umbrella of public health, safety, and welfare. You know, if there is something about the application, or something about the proposed use that is clearly presenting some danger
Noise.
to the town,
traffic,
something clearly
pollution.
odious to the community, that is generally, and I'm speaking very broadly because I don't have to be the attorney here, a fairly safe basis upon which to deny. Like we have legitimate fears that this might explode.
Okay, yeah.
Okay, so that's a public health, safety, and welfare question. You are very well within your rights to deny an application because it failed to meet some small element of the, you know, that we wanted color renderings, and you went through the whole process and they never submitted color renderings. They would then just be able to, you could deny it on that grounds. You're totally within your rights to deny it on that ground.
Well, they'll just come
But
back.
then they would just come back.
Yeah. Well, my point is, maybe somebody wants to build a restaurant, and they are looking for a special exception for it. And they give us a rendering, and it looks like something that belongs on the Strip in Las Vegas rather than on US 1 in Clinton. It's got garish, it's got, artificial palm trees, it's horrendous.
You have design standards in your regulations
Okay.
that would give you some basis for
We could
that.
deny the special exception.
If it's clearly out of
based upon
context.
it not conforming to our design standards, or if we thought that it would have a very severe adverse effect upon nearby property values.
Who would do that? You're gonna in business. Nobody would do something like that.
We're
I mean,
trying to,
I'm sitting here listening, and everything is negative.
I'm just trying.
Everything we talk about is how we're gonna not approve something. I can't believe it.
No, we're trying to define the circumstances under which,
Common sense tells you what's going on when you have the regulations in front of you, all right? And the application, the engineer's report, all right? The land use report, and then from there, we make a decision. Otherwise, why are you here? Just go home.
I have one other question, which was about the expertise area. You said that if the person brought in someone who was a recognized expert in a particular area, okay? And if I happen to have expertise in that same area, and I know that what he's talking is nonsense, the best approach then is for me to say, what? We need to get a second opinion because I have severe reservations about this, or what?
All right, there's layers in that question, and at the very least, you need to demonstrate, you need to put on the record your expertise and the reason why you question it. The next best, or better yet, you do that, right? You state on the record why you have concerns and you think the expert is wrong. And then if you can get an independent expert, because there's one case came out of Litchfield, not everybody thinks it was decided accurately, but it was a historic district commission, and a member of the commission had some expertise and was very, very adamant in her, I believe it was a woman, her position, and the court ultimately said that basically it had prejudiced the board to the degree in which this person participated in the deliberations and presented her opinions as that of an expert. So there's some case law that would say that if you could just put your expertise on the record and give the commission a reason why they ought to reject that expert, that should be enough. But I would recommend you go to the next step so that instead of relying on what one of the members of the commission said, you've called it into question, you put your expertise on the record as to why, and then you recommend to the body that they get an independent person to look into that question that you've raised.
Okay, and keep the public hearing open until such time.
Yeah, because you don't want to be cross-examined by the applicant about
Well, it's as if you're being put in two different roles. You're both a witness and a jury.
I'd just like to respond to Mr. Neary, and that is, regardless of what decision this body makes, it can still be challenged, whether you're in favor or against. If there's somebody in the public who's opposed to it, they can use the procedures of how we reach that conclusion. So, I mean, all of this, I think, is to find out whether we vote in favor of something or against something, that we try to minimize the chances of that being overturned. One of the things, though, that I think we did on the global that I thought was really smart was we had 2 resolutions prepared, that the CEO prepared 2 resolutions, and we didn't know what decision we were going to make. I think it's important, if we are going to prepare a resolution in advance, that we always prepare 2 resolutions, because it looks like, the fix is in, even though that's double work. Do you agree with that, or do you think it's important if we're going to do a resolution in advance?
It's not necessary, and certainly a staff person can read the tea leaves. It's ultimately the body's decision, so a staff person can come in with a resolution, and the board doesn't even want to make the motion because they just don't agree with that. Right. So it's not the death knell if only one comes in. In a perfect world, yes, you get both of them, so you got it. You have a jumping off point on both sides of the argument. especially in a hotly contested case like Global. So I agree with you, it was a good strategy. I don't know that you need to do it every time, though, and there's certainly no law that says that you have to do it.
No, I mean, if the decision's a layup one way or the other, you know, you can just kind of, after the hearing is closed and you have a little bit of deliberation, you can say, well, you know, we think that it satisfies the regulations, but here's some, you know, conditions and stipulations that we might want to put on an approval. You know, can staff put something together for us for the next meeting? You know, if it's a case of, you know, we want the lights to be full cutoff and maybe, you know, realign the north driveway, I don't think that they need to go through the exercise of concocting a motion to deny, you know, just so that it looks like there were two different things. But, you know, I think Global was something that arguably could have gone either way depending on how you read the facts and, you know, how you analyzed it and what the commission felt was or was not important at a given time. So I think it probably was a very useful exercise to flesh out the deliberations and to, you know, to get more into the record about how you arrive at your conclusion than, you know, you close 14 hours of public hearing and say, all right, motion to approve, anyone? You know, it just made it more obvious that you have thought about it.
Shall we move on to John? Let you guys off the hook. Thank you.